Good afternoon, everyone. My name is Stephanie Atkins. I'd like to welcome you to Harvard Bookstore. Today, I'm very pleased to have Susanna Rankin Bohme here to discuss her book, Toxic Injustice, a transnational history of exposure and struggle as part of our Friday Forum series. And now I'm very pleased to introduce Susanna. Currently Associate Director of Research at Corporate Accountability International, she has taught at Harvard, Brown, and the Rhode Island School of Design, and served as Deputy Editor of the International Journal of Occupational and Environmental Health. Her work as both academic and activist is focused in the fields of public health and environmental history and policy. Toxic Injustice, her first book, tells the decades-long history of the pesticide known as DBCP. Despite signs that the chemical was dangerous, it was widely used in U.S. and Central American agriculture for years.
So I started work on the project that would become Toxic Injustice while I was in graduate school and working at a litigation consulting firm. At the consulting firm, we worked mostly with plaintiff lawyers, mostly on toxic tort cases. While I was working there, I learned about a set of lawsuits that, unlike most of the cases that came through the office, had a transnational dimension. They involved former banana workers from Central America and elsewhere who were bringing suit against transnational fruit and chemical companies, Dow, Shell, Dole, Chiquita, and a few others, with claims that exposure to this pesticide dibromochloropropane, or DBCP, had made them sterile. So Toxic Injustice is my attempt to focus in on these workers and these corporations, to look at their relationship with each other over time, how the lawsuits came about and how they proceeded, and how workers both shaped and responded to the lawsuits. So what I've ended up with, I think, is best described as a story of lived globalization. That traces, on the one hand, DBCP's creation, circulation, and use in the 1950s through 1980s, and on the other hand, efforts since the 1980s by workers and others to demand justice for the harms associated with exposure to the chemical. So the book is concerned with how corporate and state power in the fields of science, regulation, and law combine to create unequal geographies of exposure, resulting in disproportionate risk for Central American agricultural workers and their counterparts in the United States. But it's also concerned with how affected workers and their allies in Costa Rica and Nicaragua organize and engage with both science and law to demand some modicum of justice, both at the national and transnational levels. So that's an overview of the book. I'm going to read selections today that I hope will give you some sense of the narrative arc of the full book, kind of filling in where necessary. But I think Toxic Injustice really is a story, so I'm going to try and give you some sense of the breadth of that story without giving you all the details, obviously. So before the first selection, I will tell you that DBCP was developed in the mid-1950s to protect the Hawaiian pineapple crop from nematodes, which are nearly microscopic worm-like creatures that feed on the underground parts of plants. Soon after DBCP was developed, it was taken up by Dow and Shell, who began to create their own branded versions called Fumazone and Nemagon. Despite finding that DBCP caused testicular atrophy and other problems in guinea pigs, as well as in rabbits and rats and monkeys, Dow and Shell were able to register DBCP for use in the United States, as well as sell it to companies like Dole and Chiquita, which were then known as Standard Fruit and United Fruit, respectively, for use outside of US borders as well. And the early story of that toxicology is early in the book, but that's the brief version. So the first section I'm going to read discusses the application of DBCP on Central American banana plants in the 1970s. And the sources of workers' descriptions that I'm going to be drawing from are either from deposition testimony given in the 1990s as part of the lawsuits I mentioned, or are from interviews that I conducted with workers during my research process. Jorge Colindres Carcamo worked as a mechanic for most of the 25 years he was employed by Standard Fruit in Coyote Central, Honduras. His responsibilities included maintaining and repairing the pumps and engines essential to applying DBCP. The chemical, he explained in 1994, would be hand-pumped from a barrel to a larger tank and then added to a reservoir holding water diverted from a canal. A mechanical pump distributed the water to turbines, which pumped the water to the top of metal towers, where devices known as mariposas, or butterflies, sprayed it over the banana plants below. Colindres came into contact with DBCP as he cleaned and fixed turbines and other equipment that would become sticky after contact with the chemical. Another laborer for Standard Fruit, Herman Munoz Moncada, who worked in Chinandega, Nicaragua, beginning in 1978, described a similar process for applying DBCP. As an irrigator, his job included climbing the towers to fix what he called not mariposas, but guns that shot out water onto the plants below. Sometimes the gun gets stuck or it goes crazy, he said, and then you have to be paying attention to go and control it. You have to climb up to correct it so it can continue. Fixing the guns often meant becoming entirely soaked in the toxic material. Workers and family members were not provided protective equipment or clothing. In the words of Jairo Ramirez Contreras, who worked at Valle de la Estrella in Costa Rica, wore, quote, work clothes, any clothes. He usually wore long pants, a short sleeve shirt, and rubber boots. He was never provided a mask, gloves, or other protective gear. Ernesto Garbanzo recalled that while some workers wore boots, they bought them themselves. While some remembered that protective equipment was given later for other pesticide-related jobs, in interviews, depositions, written accounts, workers overwhelmingly reported that no protective equipment was given for working with DBCP. In 1976, a consulting nematologist, an expert in nematodes, from Cornell University admonished United Fruit because safety precautions for DBCP were not being observed during his visit to the Bocas, Armuelles, and Golfito divisions. Specifically, he wrote, quote, soap and water were not readily available to wash off DBCP spilled on parts of the body, particularly areas such as eyes. Also, it was evident that DBCP was being spilled on clothing, and it appeared likely that these clothes were not changed at the end of the day's work. It is suggested that each person be supplied rubber boots and coveralls, and that these coveralls be washed by the company at the end of the day. The recommendation, that's the end of the quote. The recommendation for protective gear points to inherent conflicts between the environment, workers' bodies, and proposed protective regimes that characterize not only DBCP use, but pesticide use in hot, humid environments more generally. Although respirators, goggles, gloves, shoes, and long pants and sleeves could help protect a pesticide-exposed worker from harm, the equipment was poorly suited to the hot and humid context of the plantations, and high temperatures made using safety equipment unbearable. The banana companies knew this. In 1974, a Standard Fruit nematologist working in Costa Rica wrote to Jack Dement, the company's director of research, explaining, even if we recommend use of rubber gloves and supply them, most workers are going to ignore them because of the heat. This reasoning was often echoed by managers and used as an excuse to avoid the expense and bother of purchasing and using protective gear. Instead of acknowledging the paradox that protective equipment use and hot weather were incompatible, or developing climate-appropriate protective equipment, the companies displaced the dilemma onto the workers. freighting them with the responsibility for ignoring or refusing protective equipment. That is, instead of signaling a problem with the system of production or the very real limitations posed by the climate, the failure of protective gear was interpreted as a failure of the worker. So understood, companies could mobilize the workers' refusal of goggles, masks, and gloves as an excuse to dispense with protective measures entirely. So in 1977, around the same time that the workers I just read to you about were applying DBCP on banana fields in Central America, a group of factory workers in Lathrop, California, who worked for the Occidental Chemical Company, discovered that it was DBCP that was responsible for the fact that 10 out of 15 of them were sterile. The California workers were union members, and they were already working with a film crew who was concerned about occupational health problems. So their discovery quickly became public. It set off an uneven regulatory process in the US that ironically exacerbated inequalities in exposure, both within the US and across borders. For example, Dole continued to use DBCP in its Central American plantations for several years without any kinds of protection for workers. So in addition to regulation, the now very public sterility effect of DBCP led to a series of lawsuits. The first lawsuits were brought by Occidental workers who received compensation of up to $2 million for claims including sterility, fear of cancer, and loss of consortium. By 1982, the first international cases were filed, or cases with international plaintiffs were filed. And the first case was called Cibaja. It was a group of Costa Ricans with sterility claims. So banana workers and their lawyers undoubtedly hoped for recovery similar to what that factory workers had received. Instead, it would be 25 years before a single banana worker DBCP case went to trial in the United States. Most DBCP cases in the 1980s and 90s were dismissed at the request of corporate defendants invoking a legal doctrine called forum nonconvenience. This doctrine was used to argue that cases would be more conveniently heard in workers' home nations. Obviously, this begs convenient for whom, right? This was really a de facto victory for the corporations, as barriers to bringing lawsuits in workers' home nations prevented most cases from moving forward elsewhere. So not all the cases were dismissed. Two major cases were settled, but both settlements brought plaintiffs nothing near the compensation awarded U.S. production workers. And the range of money that banana worker plaintiffs ended up with in these settlements was varied, but it, I think, topped out at maybe $10,000. By 1997, when a case called Delgado was settled, tensions had emerged not only between plaintiffs and defendants, but also between banana workers and their own lawyers. These tensions were stoked by setbacks in the troubled litigation process, but by and large centered on conflicting understandings of the damage that had been caused by DBCP. And I'm going to read you a little about that process as it played out in Costa Rica. And just a note, I will be using a word, afectado, which means affected, and it's the word that was used as a noun to describe Costa Ricans, banana workers, or others who were exposed to DBCP during their work for Dole or Chiquita. In June 1997, news of a settlement in Delgado hit the Costa Rican press. La Nación reported that Dow would pay $22 million to a total of 25,000 workers, including 6,000 Costa Ricans. Before DBCP affected workers received their share, however, almost 17 million would be deducted, 8 million in expenses and 8.8 million in lawyers' fees. Ex-banana workers who had filed lawsuits, but whose conditions did not meet the official definition for azoospermia or oligospermia, and those are terms for absence of sperm in the semen or fewer than 20 million sperm per milliliter of semen. So workers without those conditions were not included in the settlement. Instead, plaintiffs' attorneys offered them payment of about $100 in recognition of their involvement with the case. About half of Delgado's Latin American plaintiffs had abnormal sperm counts, meaning that the other half may have received only symbolic payment. Critics of the settlement took issue mostly with the fact that plaintiffs who already had had children or who had medical conditions other than sterility had been excluded. Afectados understood their exposure to the chemical to be the cause of a number of other symptoms and diseases other than sterility, including cancer, bone and muscular pain, vision loss, skin problems, and kidney pain. Some workers also found it unfair that the fact that they had had 4 or more children, even before exposure to DBCP, would exclude them from the litigation. One man claiming DBCP-induced damage, Plutarco Hernandez, asked, how is it possible that they disqualify people just because they had children before they used the toxin? Miguel Villalobos agreed. It's an injustice. I am sterile, he said, maintaining that the fact of his sterility should have qualified him for compensation, regardless of children born before exposure. The disjuncture between worker and lawyer definitions of DBCP-caused harm provoked protests on the part of labor and human rights groups, who, according to La Nación, saw the settlement as inhuman, irrational, insufficient, and unjust. So the range of illnesses that afectados linked to DBCP went well beyond the signal problem of sterility. Many of the conditions that they mentioned and they attributed to the chemical were already implicated by animal testing and other human evidence. DBCP was a recognized animal carcinogen and considered a probable human carcinogen by the International Agency for Research on Cancer. Published scientific research also reported DBCP caused damage to the kidney and liver and showed evidence of reproductive problems in women and birth defects in offspring. But workers' attribution of health problems to DBCP reflected social as well as scientific processes. Former banana workers were likely to have experienced a number of occupational exposures, not only to pesticides, but also to long workdays and hard physical labor. Those exposures left their mark. But most banana worker health problems did not receive much public attention. Therefore, as afectado activism intensified and the health harms of DBCP gained attention, and as litigation presented the chance of financial recovery, former banana workers with ailments could easily identify with the movement. Attributing a wide range of problems to the nematicide made common sense. These illnesses emerged from the same historical context of DBCP damage did. A system of banana production that had little regard for worker safety, paid poverty wages, and used up workers through intense and sustained demands on their bodies. Workers knew from experience that work had hurt their bodies. The focus on DBCP suggested a specific cause of that damage. Attributing a wide range of diseases to DBCP also presented some hope of financial gain. Litigation presented a rare opportunity for banana workers to win compensation from the fruit and chemical companies who had so powerfully shaped their lives. It was not surprising that banana workers blamed a range of problems on the chemical, while lawyers wedded to a narrow set of scientific and legal strictures for causation, focused on the signal disease of sterility. In Costa Rica, this disjuncture between afectado understandings and medico-legal strictures spurred discontent and action in Costa Rica. And as the movement built there, Costa Ricans were, over many years of protest, able to win compensation. But Costa Rican afectados took as their target not the fruit and chemical corporations, but rather the Costa Rican government. So they used protest, and they also used alliances with occupational health researchers within Costa Rica to push for a national state compensation program that was more closely aligned with their own conceptions of DBCP harm than the settlement guidelines had been. The law that they achieved the passage of compensated sterility regardless of the number of children a man had fathered, and also included compensation to women who had been exposed to DBCP, as well as to men with complaints distinct from the sterility complaint, including, for example, impotence associated with sterility. By 2009, 14,000 men and women had received compensation under Costa Rica's DBCP law. Now, this was a huge success with two major drawbacks. The compensation amounts were very low, just a few $1,000s per person, certainly nothing near that 2 million California workers had received. And also the fruit and chemical corporations, many blamed for the exposure, did not contribute a penny to this compensation program.
Just a clarification question. On those other lawsuits, the folks who were excluded, was that part of a, because of prior offspring, was that part of a class or individual?
There were many suits, and some were class action and some were mass torts. So in the last chapter of the book, I write about a different tack taken by Nicaraguan afectados. Like Costa Ricans, they made the state the target of their protests. But they did so in a way that they hoped would ultimately convert the state into their ally in holding transnational corporations accountable. So in the words of Victorino Espinales, who is a leader of the afectado movement in Nicaragua, they, quote, pushed for the adoption of a specific law for those affected by the use of nemagon, which will enable them to sue multinationals. And I'm going to read a little about that law. The bill that would become Law 364 sets special conditions for DBCP affected people to bring cases against the fruit and chemical transnationals in Nicaraguan courts. If passed, it would establish that if a plaintiff could prove both exposure and sterility, there was an irrefutable presumption of causation, sparing plaintiffs lengthy or invasive questioning about their personal or work lives. It provided for the inclusion of claims for any, quote, physical, psychological, or pathological, end quote, issue caused by the chemical. Further, it designated minimum award amounts for oligospermia and azoospermia, specified an expedited procedure for trials, and guaranteed legal assistance to afectados unable to afford legal counsel. The law also sought to impose obligations on defendant corporations that were strict enough to bring an end to any defense argument that Nicaragua was a more convenient forum than the United States. Defendants would be obliged to post a bond of $100,000 for each plaintiff in order to participate in the litigation, which would be used to cover the cost of the suits as well as to pay any awards, and post an additional bond if the case was not resolved within 90 days. And most definitively, the bill established that defendants who fail to pay the required bond, quote, shall submit unconditionally to the jurisdiction of the courts of the United States of America. The eventual passage of Law 364 made Nicaragua a key site in the transnational struggle over DBCP justice and compensation. The stakes of the Nicaraguan litigation became crystal clear as the first cases were filed in Managua. In late February 2001, 100 Nicaraguans filed claims for between $300,000 and $500,000 US dollars each for injuries caused by DBCP. So the first Nicaraguan verdict under the law, Judge Vida Benavente ordered Dow, Shell, Dole, and Standard Fruit entities to pay over $489 million US dollars to 446 plaintiffs. And other equally huge verdicts would follow in succession. So although they had previously argued that Nicaragua was the appropriate forum in which Nicaraguan banana workers should bring their cases, the transnational corporate defendants now refuse to pay the verdicts. None of them had significant property or investments in Nicaragua, meaning they could flout Nicaraguan law with impunity. On January 13th, 2006, Judge Benavente announced what seemed like a way to force the companies to respect Nicaraguan jurisprudence without looking beyond national borders. I'll step back for a minute to note that some lawyers had tried to enforce cases decided in Nicaragua in courts of other countries, including primarily the US, without success. Judge Benavente would enforce her own verdicts by embargoing Dole and Shell's trademarks. An expert would be called in to determine the value of the trademarks, which would be auctioned off if the company did not pay the $550 million US dollars in judgments against it. Jubilant banana worker activists and their attorneys responded by demonstrating at a Shell gasoline station in Managua. Supporters expressed satisfaction that in Nicaragua, quote, even a transnational with global prestige was made to respect the law of the country. Shell and Dole, however, looked outside Nicaragua for a resolution to Benavente's action. Like many other treaties and trade agreements, the Nicaragua-Netherlands, Shell sought to solve this problem by invoking a bilateral investment treaty to bring the Nicaraguan government into arbitration. So the Nicaragua and the Netherlands had a bilateral trade agreement that allowed investors, including corporations, to bring national governments into dispute resolution processes. On May 17th, Shell Brands International and Shell Nicaragua alleged that by seizing the Shell trademark, Nicaragua had violated the treaty. So they filed a request for arbitration at the International Center for the Settlement of Investment Disputes, or ICSID. ICSID is an organization that's part of the World Bank Group. It was established by a 1966 World Bank Convention, and it serves as a forum for the resolution of disputes between investors and nations that have signed on to the ICSID Convention. So the call for ICSID arbitration forcefully underscored the limits of the Nicaraguan state's power to hold the chemical company accountable for harms done by DBCP. Having already consented to ICSID arbitration by signing the investment treaty, Nicaragua was bound to respect the process or potentially endanger its relationship with the Netherlands. The arbitration suit had the effect the corporations had hoped for. On June 13th, 2006, exactly 5 months after Judge Benavente had instituted the embargo, a temporary judicial replacement granted a Shell motion to reverse the embargo. So this failure of enforcement left two options for Nicaraguans, right? It was clear at this point that the Nicaraguan government would not be able to enforce decisions by Nicaraguan judges. So One was to continue trying to enforce these cases in third-party countries like the US or Ecuador. And the other option was to bring suit again in the US, as Law 364 now protected US cases from dismissal, as no defendant would now argue to a US judge that the case should actually be tried in Nicaragua. So when I finished the dissertation version of this book in 2008, it looked like the Nicaraguan strategy had succeeded in holding corporations accountable for the harm caused by DBCP. And that was because in 2007, the first DBCP case ever with banana worker plaintiffs went to trial in the US. They were Nicaraguan plaintiffs protected by Law 364 in their efforts to bring suit in California. They won a measured victory. 6 out of 12 plaintiffs won about $6 million in compensatory and punitive damages from Dow and Dole. It seemed at that point like a happy ending. Then time passed. Unfortunately, over the next few years, kind of bizarre and complicated scenario played out in which Dole made a series of fraud claims against banana workers and lawyers alike. The corporation and its law firm described their tactic in a publication called Corporate Counsel, and what they named their strategy was the kill step. At the center of the kill step strategy was discrediting witnesses as well, plaintiffs as well as lawyers. What they did in order to do that was to bring forward witnesses who were alleging fraud on the part of plaintiffs and simultaneously claiming that they were afraid for their lives if their identities were made public. The judge in that case responded by granting sort of unprecedented secrecy to these witnesses, preventing plaintiff lawyers with knowledge of Nicaragua from knowing their identity, from cross-examining the witnesses, or asking other witnesses to confirm or deny any of the statements made by the secret witnesses. The US-based lawyer on the case who spoke Spanish and who had experience in Nicaragua was also excluded from the case, leaving another US law firm with no knowledge of Spanish or no knowledge of the case on the ground to defend the case. It's a long and strange coda to this whole story, but it was a strategy that worked for Dole and its co-defendants. The judge in the California court was Victoria Cheney, no relation to Dick Cheney, but she was a Republican appointee, and she did grant a series of defense attorneys' requests to both throw out part of that historic award and eventually throw out that overturn that jury decision entirely, as well as dismiss 2 similar pending cases. And I'm going to end just by reading a little bit of that judge's oral ruling terminating those 2 other cases, so you have a sense of the litigation atmosphere in this last case. In an oral ruling made on April 23, 2009, Judge Cheney terminated Mejia and Rivera before they could go to trial on the grounds that plaintiffs had perpetrated a fraud on the court. The judge's ruling was remarkable for the disparaging terms in which it described Nicaragua and the people involved in DBCP-related activism and litigation. What she saw down there in Nicaragua was, quote, an odd social ecosystem, end quote, with one mythical creature serving as a metaphor for the DBCP litigation, a chimera that is really, truly heinous and repulsive, close quote. US and Nicaraguan attorneys were the brains of this beast, and captains who recruited clients were the eyes and arms that reached out and grabbed men to make spurious claims. end quote. Acknowledging her own lack of familiarity with Nicaraguan politics, quote, the Sandinista revolution changed the system of government there. I'm not quite sure what it's been replaced with. I know there is a government there. I have no idea how well it's really functioning, close quote. Cheney, nevertheless, despite her lack of knowledge, painted a racist and xenophobic picture of Nicaragua as a lawless place whose childlike inhabitants were incapable of self-government and prone to corruption. Quote, there is a lack of respect for law, apparently, down there, she wrote, adding that she questioned, quote, the authenticity and reliability of any documentary evidence presented by plaintiffs that comes out of Nicaragua. Just as a side note, she did say down there multiple times during this ruling. For Cheney, the problems she saw in Nicaragua rendered the DBCP cases irretrievably tainted. Discussing the possibility of allowing Miller Axline, the US-based plaintiff lawyers who she deemed unimplicated in any fraud, to continue the cases, she asked, what are they going to do? Go back? Who are they going to talk to? They're going to talk to the same people who put up and claim that Joe worked with John on the banana plantations. But Miller Axline doesn't have the ability, any more than Dole or Dow or AMVAC, to check the authenticity of that. End quote. To back up her findings in this case, Cheney cited the U.S. State Department and trade representatives' negative findings on Nicaragua's judicial system, which had, in fact, been at least in part prompted by the DBCP defendants' own petitions to those agencies. In Cheney's view, Nicaragua presented such an impenetrable fog of fraud that the truth was simply not available there. The cases, in her opinion, also posed a threat to U.S. jurisprudence, this time in the form of a metaphorical plant with roots in Nicaraguan courts, but whose fraudulent shoots had extended north. She said, quote, there has been a strong attempt to bring the seeds of the Nicaraguan corruption here to this country. So I'm going to end on that note, both sort of because I think the sort of dark irony of Cheney's assessment of the sort of nature and direction of transnational threat is remarkable, right? She is seeing Nicaragua as a source of threat to U.S. jurisprudence while entirely dismissing the history of a much more dangerous material flow in the form of this chemical from the U.S. To Nicaragua and elsewhere. But I think this quote also really suggests that the same disregard for workers' lives, for Latin American workers' lives, that animated the use of DBCP in the 1970s, that early use without any protections or warning, continues today in the judicial forum as well as in agricultural practice, because DBCP was far from the last dangerous pesticide used on bananas or any other crop produced in the context of industrial agriculture in Latin America or elsewhere. So despite this kind of downer of an ending, I think what I draw from this story is the fact that afectados movements, with their measured successes, as well as their failures, or it may be more precise to say the victories of the corporations, the afectados movements really do help show us a way forward to a different future where this regard for human life hopefully will not be as prominent. Thank you.
Were there any precedents about people from other countries suing a transnational company inside the U.S. before the Nicaraguans brought their case?
Yeah, and in the book I talk about this. These DBCP cases with international plaintiffs were really part of a growing interest in on the part of U.S. plaintiff lawyers in the early 80s as a way to bring, to see the U.S. courts as a forum for international justice. And I try in the book to place this in the context of the growth of neoliberalism and the Reagan-era politics, and generally left-leaning plaintiff lawyers' desire to sort of recuperate a place for a sort of regulatory space within the litigation environment. Also, obviously, there's a lot of the world's attention was on Central America at this time. So, as far as the litigation context, this was also the point around which some cases were being brought around the Bhopal chemical disaster, which those cases were unsuccessful as well. Those cases were brought under different kind of case. They were brought under the Alien Tort Claims Act, whereas the DBCP cases were sort of garden variety torts. But in both of the case, both sets of litigation, it was the forum nonconvenience doctrine that was really successful, that defendants were able to successfully use to dismiss cases from U.S. courts. Does that answer your question?
Yeah. So I guess there's been no successful.
No. I mean, there's a Costa Rican case that could still play out in the DBCP realm, because one of the cases that was dismissed under Delgado was sent to, it was another case, was sent to be litigated in Costa Rica, and the judge who dismissed it said, oh, if it moves through the entire court system in Costa Rica and it's not heard, then it can come back to the United States. And those cases are still pending, although some of them may have been settled. There have been some big settlements over the past couple of years, and it's sometimes hard to know exactly which cases have been covered in that settlement. Usually those are confidential.
You talked about basically one chemical, handful of companies, but is there any database? I mean, how extensive is the problem? I mean, we're talking about dozens of chemicals, dozens of countries.
Mm-hmm. Do you mean with DBCP specifically, or with pesticide illness? Yeah, it's a huge problem globally. I don't have the stats at the tips of my fingers, but I think, pesticides are designed to interfere with life, right? So the same way that they poison creatures, they generally have some level of toxic effect on humans. A couple databases, a Pesticide Action Network maintains a database that is really good for looking at toxic effects of particular pesticides. There's a project out of California that has tracked U.S. exports of pesticides that are outlawed in the U.S., which is a group that DBCP belongs to, right? And U.S. pesticide regulation explicitly exempts exported pesticides, so it can be illegal to use a pesticide in the U.S., but it's fine to export it if it can be legally produced here. So there's a huge loophole to be closed there, although starting in the 70s there were some notification provisions built into pesticide regulation, but that export market for pesticides is a huge problem that sort of has come into public focus and then fallen out again a few times without any kind of systemic regulatory solutions.
And we tend to hear about U.S. companies, Dow being notorious, but
sure.
But to what extent does it apply to European or Chinese companies?
Right.
And are the legal remedies any better in those, for chemicals originating in those places than they are in the United States?
Not in terms of export protections. I think there are the regulatory regimes are different in different countries, and also that you have to think about enforcement as well, right? Like Costa Rica actually has a pretty good set of pesticide laws and has for a while, but the enforcement just isn't there, right? Also, you increasingly see a situation where rather than being produced in Japan or the US or Germany, pesticides are produced by subsidiaries or smaller corporations in the various countries they are used in. So that gets around any kind of import-export restrictions, and obviously presents a set of challenges around global flows.
The legacy, if you will, of the use of DBCP continues on the health dimension. But what about its actual use in the field? What's your sense of that?
It's no longer used. And one of the arguments I make in the book is about is that national regulations in the U.S., despite the explicit exemption of exported pesticides from the normative set of regulations, that national regulations have an incredible impact transnationally, and that can be a positive impact or a negative impact. In DBCP's case, for example, OSHA, who's responsible for regulating production workers or industrial workers' health, regulated the conditions of DBC production much more quickly than EPA, who's responsible for protecting farm workers. And what that did was it meant that it was very hard to produce. It was harder for the chemical companies to produce DBCP in the US and adhere to regulations, but there was still a market for DBCP in the US. And what you saw then was one chemical corporation, AMVAC, setting up who's from Southern California, just moving across the border and producing DBCP in Mexico, where none of the production regulations applied, in order to sell it to US markets. So that's what I mean when I say that both the inequalities in exposure increased during this phase of accelerated regulation, and also that national regulations can have many effects transnationally.
And just as a quick follow-on, I know you mentioned PAN. I don't know if it's still around. There used to be an organization, I think it was the National Coalition for Alternatives to Pesticides, or PAN, something else.
Yeah, I think they're still around.
So in terms of the DBCP no longer being utilized, bananas are still grown, obviously. So do you have a sense of what is used?
Right. Yeah, there's a variety of nematicides that are used. Mocap, Nemacur are ones that historically were substituted for DBCP. The industry line, when threatened with cancellation of a pesticide regulation, is always like, oh, we need this pesticide in order to continue profitable production. In the case of DBCP, the standard worked with Dow to create an argument for the EPA for continued use of DBCP on bananas, and the argument was something like, well, it should continue because otherwise the price of bananas is going to go up a penny a pound for US consumers, right? And that EPA accepted that analysis. That wasn't the final EPA say, but along the way. It's a really complicated story, but yeah, so generally there are alternatives. Sometimes they're more expensive. And I think that's suffuses this book, is that that there is this imperative to keep costs down, right, which is obviously bad for workers who end up bearing the brunt of the saved costs. Any other questions? I just think I'll take my moment at the podium here to mention I talked about the ICSID arbitration and that I would just note that right now the U.S. is considering becoming party to a new trade agreement, the Trans-Pacific Partnership, which includes investor-state dispute settlement clause. And what that clause does is create the conditions for corporations to bring national governments into arbitration around national policies. So policies meant to protect workers or protect the environment can, under the conditions of these trade agreements, be arbitrated at these supranational forums with zero democratic control. So if that part of the story bothered you, I would encourage you to read up on the TPP and do what you can to keep it from moving forward. Thank you.
I wrote onomatopoeically across the cover page of the screenplay in big black letters. Then I capped his pen, put it back on his leather writing pad, and said, "That's how we scream in my country."